Hillsborough County State Attorney Andrew Warren is our guest today. We are talking about Marsy's Law, or Amendment 6, that Florida voters passed in November. This is a measure that you supported. Thanks for being here to talk about this.
Absolutely, Holly. Thanks for having me back on the show.
So since it has been essentially implemented, I know there might be some legislation to kind of clarify some things, but starting in January, to protect victims' rights, what, if anything, has your office had to do differently?
Sure, so let's take a step back for a moment and talk about what happened in November. When voters passed the Victims' Rights Amendment, they spoke with a strong, unambiguous voice that Floridians support and protect victims throughout the judicial process. And I've sat with victims and their families at some of the most difficult, vulnerable times in their lives. And to now have their rights enshrined in our Constitution is a great thing because it puts it on par with other ideals for how our government should operate.
And it does a number of things. You have to now notify victims of any hearings coming up through the court system that their alleged perpetrator is going to appear at. Their names are now not part of the public record. Perhaps that's being looked at by different agencies in different ways, so there's some clarification that is needed there. We'll touch on that in just a second. But some defense attorneys in other states where this has been implemented, they have said it puts an undue burden on the defendant's rights because they've had an accelerated timeline now of when they have to get to court. Could that be an issue here? Are we forced now to move things so quickly through the courts that defendants aren't getting a fair trial? Is that a valid argument?
No, I don't think it is. I mean, defendants' due process rights are guaranteed in the U.S. Constitution, and nothing in the Victims' Rights Amendment in the Florida Constitution interferes with or supersedes those rights. So just to talk about some of the things you touched on for what this amendment does, it protects victims from harassment. It protects their privacy. It makes sure that they have a right to be informed at every step throughout the process. There's a restitution element in it to make sure that victims are receiving their restitution without the government taking a cut from it. And a lot of people don't know that government agencies had the right to sort of take money from victims' restitution before they got that. I think that's completely unfair. We shouldn't be funding government on the backs of victims. Another part of it is this aspirational goal of how quickly a case should move through the system in terms of getting to trial and for the appellate process.
And that aspirational goal is 2 years to go through the appeals process for a non-death penalty case and 5 years for a death penalty case. And public defenders have argued that that's just simply not enough time, that they don't have the resources for that. Again, is that a valid argument in your opinion?
Well, it may be, but the reality is that to have an aspirational goal for how long a case should complete in its appeal is a good thing. We shouldn't have victims and their families waiting around for years and years and decades before they have closure from the case. In 2 years for a non-capital case, in 5 years for a capital case is a reasonable goal. Now, are we going to hit it in every case? No. But the amendment gives a safety valve for judges to say, okay, in this situation, I find good reason that we can't complete the appeal within that 2 year or 5 year set. In those cases, there'll be more time because we do want to make sure that defendants' rights are upheld while also protecting victims' rights.
And you brought up restitution. I don't think there's anybody out there who would say, oh, they shouldn't get the restitution they deserve. Of course they absolutely should, but there's also a clause that says direct and indirect costs, and there's an argument out there that we are now going into the criminal side, things that used to be civil litigation, because indirect costs is something direct, like, oh, your hospital costs if you've been injured is one thing, but this whole indirect issue is a little ambiguous, don't you think?
Well, again, what the amendment does is it sets out the process by which the victims get their money first. So victims are getting reimbursed and restituted for direct and indirect costs. The amendment makes sure that no one else is taking a cut of that. But as you alluded to in the beginning, the constitutional amendment sets forth the structure of how it should work. And then the legislature comes in and fills in some of those details. So we'll be working with the legislature to make sure that they're filling in those details in a way that actually achieves the purpose of the amendment to protect victims from the very beginning.
And one of the areas that has really had an impact on reporters here in our market is this issue of should the names be released to the public. We've seen that play out differently with different agencies. Crime victims that their names are not released to the public in Tampa or Hillsborough right now in what they believe is the reading of this law, but yet in Pinellas County they're still releasing those victims' names. That is something that you have people who are reading it differently. Should these names be released to the public? In your opinion, what do you think is happening here and what needs to happen?
Well, this is a matter for the legislature to provide guidance on. But what's important to me as the state attorney is making sure that we are protecting victims and giving them the privacy that they need if they want it. So a victim, even at this point, can choose to have his or her name and information released to the public. But if they don't want to, we shouldn't be subjecting victims to unwanted harassment from the very beginning of the process. And it's important to keep in mind, we have a lot of victims and witnesses who are unwilling to come forward because threats that are made against them or intimidation tactics that are used. This is another mechanism that we now have to protect victims, to make sure that we're holding offenders accountable throughout the process without intimidation or harassment against victims and witnesses.
I think there is going to be the argument, there already has been from the First Amendment Foundation, from certain agencies around town who feel like people might not fully understand that, like take, for example, the Seminole Heights murder case. That's something everybody knows about. When those victims were found, of course, at that time this law didn't exist, so their names were public. And reporters could go out and do their job, and we could say, wait a minute, something's not adding up here. These people are completely random. Their families have spoken to us. None of this is making sense. This isn't some kind of a turf war with gangs or drugs. These people don't have records. You can start to put things together because this has always been part of the public record. And now it would not be, perhaps, or it would not be for sure. And you lose the ability to really report things that the community needs to know. I think that's the argument behind that. Would you agree with that to an extent?
Well, I agree that that's certainly something the community has a right to know. But again, nothing in the Victims' Rights Amendment infringes on the First Amendment in the Constitution. I mean, the idea that this is somehow limiting free speech is a non-starter. It just doesn't work that way. What's going on now is different agencies are figuring out how to interpret this aspirational structure of a constitutional amendment in a way that makes sense with the gap that's being filled by the legislature. We're going to get clarity during this upcoming session so that news organizations, victims, prosecutors, law enforcement, everyone understands exactly what their obligations and responsibilities are.
And I think we all understand nobody wants to make anything harder on crime victims, and that's why voters passed this, and I certainly understand. There's just, like you said, there's going to be some clarity that needs to be outlined, and that is the job of the legislature coming up. So Andrew Warren, we appreciate your insight as always.
Thank you so much.
Thank you.